It was supposed to be a routine morning in courtroom 4C of the Cincinnati Federal Courthouse. Rain painted streaks across the tall glass windows, and the distant rumble of thunder echoed like a subtle warning. The gallery was quiet. Law clerks whispering, reporters adjusting their camera angles, a few onlookers sipping from lukewarm coffee cups as they waited for another high-profile hearing to begin. But none of them, not even the judge presiding, anticipated what was about to unfold. Judge Harold Whitmore, a stern man in his early 60s with a jaw like granite and a reputation to match, sat perched behind the bench, flipping through a folder thicker than most criminal appeals. He had seen his share of courtroom dramas, and he had presided over some of the most contentious political hearings in Ohio. He was not easily impressed, or so he thought. "Call to order," the bailiff announced. "The matter of Vance v. U.S. Commission on Executive Conduct is now in session." The courtroom doors opened, and JD Vance stepped inside. There was no fanfare, no entourage, no political theater. Just JD in a navy suit, holding a single black leather folio under his arm, walking with the kind of calm that doesn't ask for attention, but commands it anyway. His expression was unreadable, equal parts composed and calculating. His presence shifted the air in the room. A low murmur rippled through the gallery. This wasn't a trial exactly. It was a hearing to determine whether Vance had violated federal ethics statutes by allegedly invoking executive privilege to block a congressional subpoena. The commission had ruled against him. The fine was $1.6 million. Today was about affirming it, and everyone expected Vance to contest it the same way most politicians would, with a lawyer, a press release, and a plea bargain waiting outside. But JD Vance brought no attorney. "Mr. Vance," Judge Whitmore said, not even lifting his eyes from the paperwork, "you are not represented by counsel today." "I'm representing myself, Your Honor," Vance replied, voice steady. That made Whitmore pause. He looked up. "That's ill-advised." "Understood," JD said, placing the folio on the table before him. "But it's appropriate." A rustle swept across the gallery. Reporters raised their pens. Courtroom veterans exchanged glances. The judge leaned back slowly. "Very well," Whitmore muttered, as though preparing for a tedious exchange. "Let's proceed." The government's legal team, 3 rows deep and flanked by advisors from the Office of Congressional Oversight, began laying out their argument. Powerful words about accountability, the sanctity of oversight, and the risk of executive overreach. They cited statutes. They referenced obscure clauses. They gestured toward the integrity of the Constitution, and JD Vance sat still, listening. No notes, no interruptions, just stillness. When it came time for him to speak, he didn't reach for his folio. He didn't clear his throat. He didn't even look nervous. He simply stood. "Your Honor," he began, "I understand the importance of the charges. But I ask that we begin not with my intent, but with the law itself." Whitmore raised an eyebrow. "The law is precisely what's under discussion. Then allow me to walk us through it," JD replied. And with that, he began to speak, not read, not argue, not plead. He spoke. From memory, he started with Article 1, Section 6 of the U.S. Constitution, then Article 2. Then the Congressional Accountability Act of 1995. Then 3 Supreme Court rulings, cited verbatim. The room went still, not because of what he was saying, but because of how he was saying it. Not a stammer, not a pause, not a single glance at a page. He moved through precedent the way a composer plays a piano, confidently, precisely, and with no wasted motion. People leaned forward in their seats. The judge sat up straighter. One of the commission's attorneys began quietly flipping through her own notes, trying to confirm that he hadn't missed a word, and JD kept going. Not to show off, not to grandstand, but to remind the room what the Constitution actually said, and more importantly, what it didn't. By the time he stopped speaking, 21 minutes had passed, and the courtroom was completely silent. Judge Whitmore cleared his throat, visibly shaken by what had just transpired. "Mr. Vance," he said slowly, "are you suggesting this court has misapplied constitutional authority?" JD. Vance didn't smile. He didn't flinch. "I'm not suggesting anything, Your Honor," he said. "I'm simply stating what the Constitution already has." The judge blinked, and the storm outside kept tapping gently against the glass. For several long seconds, Judge Whitmore didn't speak. The courtroom's stillness felt heavier than before, like gravity had increased just for that room. His fingers tapped slowly against the mahogany bench, not out of impatience, but calculation. He was rereading a mental script, flipping through every precedent, every assumption, every procedural shortcut that had led to this very moment. And now, staring at JD Vance, he found himself in unfamiliar territory. Not because he faced resistance, he was used to that, but because the resistance was prepared. "Mr. Vance," Whitmore said finally, choosing his words with care, "reciting the Constitution is admirable, but this hearing concerns a violation of specific federal conduct statutes, not philosophical disagreement." JD took a small breath and stepped slightly closer to the podium. His voice remained even, neither defensive nor dramatic. "With respect, Your Honor, it's not philosophical. It's structural. The authority to penalize executive privilege is contingent upon limitations set forth in the Constitution, and those limitations are explicit in both text and precedent." He reached into the folio, not to pull out a document, but only to place a single page on the desk. It was a printout, one line highlighted. The judge didn't move to take it yet. Instead, JD continued. "The legal foundation for this fine, Statute 1924B, only applies if executive privilege was invoked outside the bounds of lawful review. But if you'll permit me to quote directly from United States v. Nixon, the Supreme Court ruled, 'The privilege is fundamental to the operation of government and inextricably rooted in the separation of powers under the Constitution.'" Judge Whitmore narrowed his eyes. "I'm familiar with the ruling. Then you'll also recall the line that followed. Absent a demonstrable, specific need for evidence in a pending criminal trial, executive privilege stands." JD paused. "This isn't a criminal trial. It's an administrative hearing on conduct, with no evidence of criminality or harm, which means—" "The court," Whitmore interrupted, "may still rule on the misuse of privilege, especially if that privilege is used to avoid oversight." "And the Constitution," JD replied without missing a beat, "places limits on that oversight. Congress has no authority to compel speech from a sitting executive without demonstrating necessity and without proper review by an Article III court. That didn't happen here. What happened was an assumption of guilt and a penalty applied before the full legal framework was examined." This time, the gallery shifted. Not a cough, not a mutter, just the sudden realization that this wasn't going the way they had expected. One of the government lawyers leaned toward the microphone, lips tight. "Your Honor, we move to object to Mr. Vance's attempt to redefine statutory interpretation from the witness stand." "Object to the Constitution?" JD said, turning calmly. "That's a bold strategy." Even Judge Whitmore cracked a faint smile before regaining composure. "Let's be clear," JD continued. "This is not about my position, or my party, or even this fine. It's about the integrity of our legal process. If courts begin issuing financial penalties for lawful silence, especially silence protected under the Constitution, then we're not upholding the law. We're distorting it." There was a moment of silence. A strange moment. Not confrontation, not submission, something else. Respect. From at least some in the room. JD Vance didn't raise his voice. He didn't storm or plead. He simply stood where he was, framed by the wood of the courtroom and the soft hum of the overhead lights, delivering what felt less like a defense and more like a civics lesson nobody expected, but everyone suddenly needed. Judge Whitmore leaned forward. "And if I told you, Mr. Vance," he said slowly, "that this court sees your argument as compelling, but not sufficient to nullify the Commission's finding?" JD nodded. "Then I'd respectfully request the court hear the rest of my evidence, because I haven't even begun to talk about Federalist 51. The judge blinked, and somewhere in the back row, a young law student smiled like he knew what was coming. Judge Whitmore shifted slightly in his chair, not out of discomfort, but interest. JD Vance invoking Federalist 51 in a courtroom already wrapped in constitutional debate wasn't just unusual, it was calculated, and the judge knew it. The entire gallery, filled with journalists, aides, and curious spectators, leaned just a little bit forward, sensing that whatever was coming next wouldn't be boilerplate legalese. It would be foundational. JD didn't raise his voice. He didn't need to. His tone was that of someone telling the truth to people who should have already known it. He placed a second sheet of paper beside the first. This one was older, well-worn even. A highlighted passage in the center, yellowed by time. "If men were angels, no government would be necessary." JD read aloud, his eyes not leaving the judge. "But because men are not angels, we must oblige government to control itself. Madison wasn't writing for comfort. He was writing for constraint, for friction between branches. And that friction, that resistance, is the very thing that ensures liberty survives." Judge Whitmore's fingers had stopped tapping. JD took a half step toward the bench. "The fine levied against me stems not from any tangible harm, not from the leaking of confidential information, not even from political misconduct. It stems from an appearance, a refusal to answer in a setting that had no constitutional authority to compel me. That is the danger Madison warned about, the assumption of power where none was granted." A murmur stirred behind the press table. Reporters took notes more rapidly now. Some even whispered timestamps for their camera teams to reference later. This wasn't a headline moment. It was a philosophy moment. A moment when law stopped being about motions and started being about meaning. "Mr. Vance," the government attorney interjected, his voice pinched, "we cannot seriously be expected to entertain Federalist Papers as binding legal precedent." JD turned to him slowly. "You can dismiss the words of our founders in theory," he said. "But if the judiciary begins to act in ways that contradict the spirit of the Constitution, even if technically legal, then what exactly are we defending in this courtroom?" He paused for effect. Let the silence stretch. The Constitution is not merely a checklist. It is a covenant, a structure built to withstand not just tyranny from without, but overreach from within. Judge Whitmore opened his mouth as if to respond, but stopped. JD had more to say, and everyone in the room knew it. "I'm not standing here to defy the court," JD said, this time with a firmer edge. "I'm standing here to remind it of its foundation. If this fine proceeds, it sets a precedent that any dissent, any protected silence, can be retroactively punished with a price tag. And if that becomes acceptable, then the next time it happens, it won't be to a senator or a vice president. It'll be to a teacher, a firefighter, a citizen, someone who doesn't have the resources or the reach to fight back." Now the courtroom was completely silent. Even the bailiff, stoic and stone-faced, stood a little straighter. JD looked at the judge once more. "All I'm asking is that the Constitution be applied not when it's convenient, but when it's necessary, especially when it's uncomfortable." Judge Whitmore leaned back in his chair, expression unreadable. No gavel, no ruling, just the heavy air of a courtroom suddenly aware that this wasn't just a hearing anymore. It was a reckoning. Judge Whitmore stared down at the stack of paperwork before him, but his eyes weren't scanning text. They were thinking, measuring. There was something about JD Vance's delivery that didn't come from a strategist's script or a consultant's notes. It came from somewhere deeper. It was constitutional law, yes, but it was also something else. Something unsettling to a system used to polite deference and predictable deflection. The government attorney tried to regain footing. "Your Honor, this is still a question of compliance." Mr. Vance refused a subpoena. His position in the executive branch does not exempt him from federal inquiry, and the fine isn't about the subpoena, JD interrupted, gently but firmly. It's about the message that's sent when a refusal to play along is treated as a rebellion. Judge Whitmore lifted his head. "And what message is that, Mr. Vance?" JD nodded once, stepping back toward the lectern. "That even the architecture of our republic can be twisted to punish silence. That if you do not comply, not because you're guilty, but because you question the authority being used, you are no longer a citizen, but a suspect." A few seats back, a gray-haired man in a military veteran's cap nodded slowly. Across the aisle, a young woman in a university sweatshirt began typing furiously on her laptop. It was a courtroom, But it felt like something more. A classroom, a town hall, a line drawn in marble tile. "I've reviewed every precedent cited in the prosecution's filing," JD continued. "From U.S. v. Nixon to McGrain versus Doherty. All of them acknowledge the government's investigatory power, but none of them suggest that power is limitless." He opened a folder and pulled out a single sheet, plain, double-spaced, a footnote highlighted near the bottom. "This," he said, "is from Watkins v. United States, 1957. A case that reaffirmed the limits of congressional inquiries. And I quote, 'There is no general authority to expose the private affairs of individuals without justification in terms of the functions of the committee.'" He looked around the room, making eye contact with reporters, with onlookers, even with the court stenographer, who had stopped typing for just a breath. "I wasn't protecting myself when I refused to comply," JD said, voice steady. "I was protecting an idea, that even when government is right in its intent, it must still be bound by its scope." The prosecutor tried again. "Your Honor, we're not punishing ideas. We're enforcing the law." "No," JD replied calmly, turning toward him. "You're enforcing silence, and that's a very different thing." Judge Whitmore held up a hand, quieting the room. "Mr. Vance, you've cited legal precedent. You've invoked the founders. But do you believe, truly, that the penalty imposed on you is an existential threat to the Constitution?" JD didn't answer right away. He folded the documents, placed them neatly in front of him, and looked straight ahead. "Not the fine itself," he said, "but the reasoning behind it. Because once we accept that government can punish someone not for breaking a law, but for questioning whether it has the authority in the first place, then we've crossed a threshold. And when that threshold becomes habit, liberty becomes memory." The judge's fingers tightened around his pen. Outside, clouds thickened over Washington. Inside, the courtroom didn't move. No coughs, no papers rustling, just the faint buzz of the lights and the distant click of cameras repositioning. The fine had once been about $50,000, a symbolic slap. But now, it felt like the tip of a very dangerous spear, one that, if not blunted, could be turned toward anyone. Judge Whitmore tapped his notepad once, and the room waited for what would come next. The courtroom had never been this quiet, not during criminal verdicts, not during heated civil arguments, not even when a former president once testified years prior in that same chamber. But now, as JD Vance stood there, no legal team flanking him, no binder-thick folders on the desk, just a man and the Constitution he'd memorized, it felt like history wasn't just being referenced, it was being made. Judge Whitmore's gavel sat untouched. He leaned back in his chair, elbows on the arms, fingers steepled. His silence was no longer authority, it was contemplation. JD Vance remained still, his closing document lying face up before him. One paragraph was underlined, not in red pen, but with the edge of memory. A passage he'd cited before, now resting like an oath reborn. The Constitution was not written in smoke and faded ink. It was carved into the bones of those who pledged their lives for it. He didn't need to read it aloud. The judge had already read it. Everyone had. And now they were waiting, because the case had changed. This wasn't about a fine. Not anymore. It was about whether defiance, if born from constitutional faith, could still mean something. Judge Whitmore cleared his throat. His voice, when it came, was not that of a man passing judgment. It was that of someone acknowledging a mirror. "Mr. Vance," he said slowly, "this court summoned you for non-compliance, assuming that your silence was rooted in obstruction. Instead, what we witnessed was a defense rooted in precedent, in depth, in clarity." He paused, as if the next words were heavier than he'd expected. "And in something we don't always see in this courtroom, principle." JD didn't move. "Your interpretation of statutory limits, case precedent, and constitutional scope," Whitmore continued, "was not merely accurate, it was exacting, relentless even. You did not argue from convenience, you argued from conviction." The judge leaned forward, setting his pen down like a verdict. This court hereby vacates the penalty previously imposed. The contempt charge is nullified. There was no applause, no dramatic gasp, just stillness. And then the quiet shift of every person in that room realizing they had just watched something that didn't feel like courtroom drama. It felt like civic renewal. Judge Whitmore wasn't finished. "But I will add this," he said, eyes fixed on JD. "What you did here today wasn't about winning. It was about reminding this system why it exists and who it belongs to." JD nodded, the faintest flicker of acknowledgement crossing his face. The gavel struck once, not in anger but in affirmation. This hearing is concluded. JD Vance gathered his papers without a sound. No handshake, no smile. Just the same measured calm that had turned a summons into a seminar. He exited the courtroom, not as a vice president or a politician, but as a citizen, one who had looked power in the face and reminded it where it came from. Outside, reporters surged, microphones thrust forward, questions shouted, but JD didn't stop, didn't speak. He just walked past the cameras, past the noise, into the wind of a capital that wasn't ready for what had just happened. And somewhere, far from D.C., in a small civics classroom, a teacher would pause her lecture, pull up the transcript, and say, This is why we read the Constitution." And every student leaned in, because in a time of headlines and hashtags, one man had walked into a courtroom and changed the story, with nothing but words and the law.